Good morning and welcome to the Tennessee Court of Appeals.
Good morning.
Morning, Your Honor.
Good morning. We appreciate you agreeing to participate with us on Zoom. It's not the method we'd all like to be doing, but obviously it is the safest method during the times that we're living in. And we appreciate you helping us move the docket along by participating with us. I want to remind each of you that although we are participating via Zoom, that the same rules and protocol and procedures will be applicable to this argument as if we were all standing in the courtroom today. That essentially means each side will have 15 minutes to make its oral argument, and if you're the appellant and have reserved rebuttal time with Mr. Hibner, you will receive that rebuttal time as well. Also want to make you aware, you already know that we are live streaming this argument, and further would like to take the opportunity to introduce your panel for this morning. We have Judge Skip Frierson from Morristown, Judge Carmen McGee from Savannah. I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
You may call the case.
Southern Steel and Concrete, Inc. versus Southern Steel and Construction, LLC et al.
All right, we will hear from the appellant.
Good morning, Your Honors. Thank you all for taking the time to hear this case this morning. My name is Linda Mathis, and I represent the appellant in this case, Southern Steel and Concrete. And this is an appeal from a Chancery Court order which granted a money judgment to my client, Southern Steel and Concrete, but at the same time made a finding that my client was the alter ego of Southern Steel and Construction, which is one of the appellees. So since the names are similar, I'm going to call my client SS Concrete and call Southern Steel and Construction SS Construction. The trial court granted a money judgment of about $107,000 to my client, SS Concrete, which had been interpled into court by Chris Woods Construction, the general contractor on this particular job. However, the trial court ruled that those funds could not be released per this judgment until another related lawsuit between appellee SS Construction and appellee Quality Iron had been resolved. But as part of its judgment, the trial court found that SS Concrete and SS Construction were one and the same, that they were the alter ego of each other, and this is the only issue that is being appealed. So it really is a factual issue, and that the court looked at that we believe is an error. Morris Rutledge and his wife formed SS Construction in 2004, and this company quit doing business in 2016 and dissolved the next year. Skip Brock was a W-2 employee. He did the estimating and project management. He could enter the contract, but only if they were approved by Morris Rutledge. He couldn't sign checks. Skip was never a member, never had any financial or management or ownership interest in SS Construction. Now, the other company is Skip Brock's company. He formed it in 2015. And he hired Morris Rutledge as a W-2 employee of SS Concrete, mainly as a crane operator. Morris was not, he did not have the authority to sign checks. He was never a stockholder. He had no financial or management or ownership interest in Skip's company, SS Concrete, the appellant. The companies had two separate bank accounts and two separate federal ID numbers. As one of the factors, the trial court noted that the two companies at one time had used the same address on West Olive in Memphis. The fact is, and it came out at trial, that particular location had been the location of a number of steel companies. It was owned by a man named Gerald Skaggs, who ran Ram Steel. When Ram Steel closed, SS Construction rented the real estate to store their equipment, but their business office and principal address, according to the Secretary of State, were always at the home of Morris Rutledge and his wife, and they conducted company business there. They did the bookkeeping, the bill paying, corporate meetings there. So in 2016, when SS Construction was going out of business, the Rutledge home was at an address on Tylertown Street in Bartlett, Tennessee. And that had always been the registered address per the Secretary of State. In August of 16, Morris Rutledge changed the principal office address from Tylertown to the West Olive address. They were already out of business at that time. And he testified that the reason he did this was personal reasons, because his wife had moved to another residence during this time period. Apparently there were some issues between the two of them. At this time in 2016, the Olive property was owned by Skip Rock and his daughter. And when the ownership, when the address was changed by Morris Rutledge, he did not inform Skip Rock that he did this, didn't ask his permission. And actually, we didn't even know about this until discovery was commenced in the Chancery suit. As another factor, the court noted that the two companies shared a phone and fax number. And the fact is, these two numbers have been in existence at that Olive building when SS Construction moved in. It was there when it moved out. They were the same numbers used by Memphis Steel, used by Ram Steel, and those two numbers continue to be used today by SS Concrete. They ran with the property. As another factor, the trial court noted that some of the same equipment was used and insured by both companies. When SS Construction went out of business, it sold the company's equipment and trucks to Fountain Leasing for $56,000. No trucks or equipment was ever sold or transferred by SS Construction to SS Concrete. And then after it was formed, SS Concrete, my client, leased its trucks and equipment from Fountain Leasing. The trial court found that SS Construction and SS Concrete had worked for a lot of the same steel erection subcontractors. But this is because they use the same employees, because these people were members of the Iron Workers Local Union 167. And because the companies are signatory contractors, they're all required to hire from the union. So it's not uncommon for any iron worker or superintendent or a foreman to work for either concrete or construction or any other signatory contractor, which is a party to the union. James Cole was the union's business manager.
Excuse me, counsel, for interrupting. As I understand, the trial court made findings that several of the same employees were hired by both companies. Is that correct?
Yes, and that's what I was explaining, is that those employees are members of the union. You have to hire from the union, and so it is not unusual for the same employees to be with SS Concrete or SS Construction or any other company that is a member of that union. So that's why there were a lot of the same employees. Yes,
let me ask you a question, counsel, as well. This information that you're providing us, and I understand this is part of your argument, but was all this information provided to the trial court as well? In other words, did all this come in as evidence that the trial court had before it and could consider?
Okay. Yes, sir. It's part of the record.
Okay. So essentially what you're saying is, and I don't want to make your argument for you, but what you're saying is that the court misapplied the law. Is that it?
Yes.
Okay. That all the evidence was there, the court just didn't analyze it correctly.
Correct.
Okay. All right. I wanted to make sure I was clear on that. I was wanting to make sure that something was not in the record that was supposed to be.
Yes, I believe it's all in the record, Your Honor. What I'm quoting to you.
Okay.
The union's business manager testified at trial, and he said that there are two different companies with two different signors. Skip Rock was the signor for one. Morris Rutledge is the signor for the other. They always recognized the two companies as being separate and that they had separate tax ID numbers. So we believe that the facts show that SS Concrete and SS Construction have always been two separate companies, and that alter ego finding of the trial court is incorrect and should be reversed.
Excuse me again for interrupting. Did the trial court make any credibility determinations?
I assume so. I mean, when the trial court made the ruling, I assume they took into account the testimony and the demeanor of the witnesses. I wouldn't have any reason to think otherwise.
I think perhaps what Judge Frierson is asking more specifically is, did the trial court determine anyone to be not credible, or did the trial court make any individual credibility findings?
No, sir. I don't believe the trial court found anyone to be dishonest or prevaricating or anything, if that's what the court is asking.
Okay, thank you.
Ultimately, aside from this argument of alter ego, my client stepped in and finished this job when SS Construction went out of business. It is undisputed that the work was done. It's undisputed that it was done properly and done timely. And the reason we're here now is that Quality Iron is trying to find a way not to pay the people that did the job, which is my client, by using the excuse that these two companies are the alter ego of each other. And since Quality has an offset clause on these on other projects, unrelated projects with SS Construction, that now that they have disputes with SS Construction, they're saying now we don't have to pay your client, SS Concrete, who actually did the work. And ultimately, I think that's what it comes down to. And we believe that the alter ego finding by the court is incorrect and should be reversed. Thank you, Your Honors.
Thank you. From the appellate.
Good morning, Your Honors. I'm Joseph Getz of the Evans Petrie Firm, and along with my partner who's sitting here off camera, Ms. Stengel, we have the pleasure of representing Quality Iron Fabricators in this dispute. Getting right to it, and I think that some of the court's questions are going to go right to my argument. The glaring deficiency, both in the appellant's argument and the appellant's brief, is the failure to appropriately cite the standard of review to which this panel should follow. In accordance with 13D of the Tennessee Rules of Appellate Procedure, this court's review of the factual findings is upon the record of the trial court, however, with some strings attached. There's a strong presumption of correctness attached to those findings, unless the preponderance of the evidence dictates otherwise. So this appellate court, in reviewing Chancellor Kyle's findings, should give great weight to the factual findings that rest on any determinations of credibility or the proof at trial. It requires this court to defer to those findings. We cite in the brief, Your Honors, the Nashville Ford Tractor case, and I'll quote it: an appellate court is bound to leave a trial court's findings of fact undisturbed unless it determines the aggregate weight of the evidence demonstrates that a finding of fact other than the one found by the trial court is more probably true. In fact, there must be other facts that support a different finding. That's clearly not the case here. And let me talk about the quality of the proof. And I believe, Judge Frierson, some of your questions went to this. Ms. Mathis, in their brief, primarily cites 90% of the citations on the facts that she is arguing are two affidavits filed in this matter by Mr. Morris Rutledge and Mr. Skip Brock. Mr. Rutledge was the principal of SS Construction, Mr. Brock, the principal of SS Concrete. Two pieces of actual trial testimony cited was one from Mr. Cole, the union representative, and one question on cross-examination that I asked Mr. Brock. So 90% of what facts are being argued here are based on summary judgment affidavits that were filed in response to a motion for summary judgment filed by Quality Iron, which was denied. We're not here appealing the motion for summary judgment. So the quality of the proof, I think it's very significant that the affidavits overlook the fact that Chancellor Kyle got to see these critical witnesses live and in person. He got to hear their testimony. He reviewed their demeanor. He reviewed the documentation they presented. And there was an assessment of credibility and demeanor. Now, was anybody called a liar? No, but he weighed all of these facts. And I will go through some of the Dorn factors. I don't want to belabor the court with those. We have exhaustively cited citations to the record, and the bulk of our citations are based on trial testimony, not affidavits that were merely filed in support of a motion for summary judgment. I submit that the affidavit proof that is strongly relied on by the appellee is really not the proper the appellant, excuse me, is not the proper evidence, this is not a summary judgment appeal. The greater weight that this court should give must be given to the live testimony. These presumptive affidavits that were solely filed to defeat the summary judgment motion, we would submit to your honors that that's the least persuasive evidence for this court to review, and certainly not enough to overcome the trial court's presumption of correctness that brings this appeal to this court under Rule 13D. We do agree with the appellant that the court applied the Road Sprinkler Fitters Union versus Dorn case, a Sixth Circuit 2012 decision, which we believe is a controlling case for review here, which goes through an exhaustive set of factors that to determine whether or not one company may be considered an alter ego of another company. And the Dorn case sets forth that analysis, and both Ms. Mass's brief and the appellee's brief goes through those factors and we argue our version of those facts and from the live testimony.
Mr. Getz,
Yes, Your Honor.
you referenced the Dorn case, which the trial court used in its analysis, and as you stated, that's a Sixth Circuit case. Do you have any Tennessee cases that set forth any? Have you found any that set forth any factors on an alter ego test, separate and apart from, or in addition to the Dorn factors?
We think Dorn is consistent with Tennessee law, and we cite in our section of the brief the CAO Holdings versus Trust case, which I think gives guidance to these corporate type relationships and corporate formation that is used in order that an injustice will not be done to a party. Tennessee courts have repeatedly held that corporate fictions can be disregarded if the corporate form is a mere sham, and such a failure to disregard this entity can be disregarded if an unjust result will be worked. The Grosselschafft case versus Tennessee Tape also stands for the proposition that by suitable evidence, it may be established that separate corporations should be treated as a single entity. And that case also goes through a multi-layered analysis that doesn't really rely on one factor. And in fact, Ms. Mathis mentioned to you in talking about, there was the same address and the same phone numbers. In fact, this is a scheme and a scam that Mr. Rutledge and Mr. Brock have played before. Mr. Brock owned a company known as Memphis Steele. You heard Ms. Mathis talking about Memphis Steele had used these phone numbers and addresses at one time. Well, when Memphis Steele got in financial trouble years ago in 2004, Mr. Brock put his buddy, Mr. Morris Rutledge, in business, who was his crane operator at Memphis Steele, and they formed Southern Steel and Construction. And here we have the same situation going on now, just reversed. Mr. Rutledge comes and gets his buddy, Mr. Brock, to jump in and form Southern Steel and Concrete, so he can maintain, keep on working in the steel industry. And so this is a shell game that these two folks had played before. So consistent with Tennessee law under Tennessee Tape and under the CAO Holdings case, we believe that this court should find that these entities are alter egos of one another, and that is consistent with Tennessee law. They should be treated as a single entity, which is in essence what the chancellor found. And so therefore, I believe, Your Honor, Justice McGee, that Dorn is very consistent with a strong line of Tennessee cases in that regard. So I hope that helped, Your Honor.
Let me ask you a question that I'm not sure it is actually relevant, but I think it could be. Number one, the briefs talk about the Vanderbilt project. Does that have anything to do with this case?
Well, it ultimately will. I don't think it has anything to do with this appeal, other than the fact that the determination of this appeal will have some outcome on that. The Vanderbilt project was a project in Nashville where Quality Iron was working with Southern Steel and Construction, Mr. Rutledge's company, Mr. Rutledge ultimately defaulted on that project, did not finish the project. Quality Iron was forced to bring in additional workers, incur additional cost of an additional $700,000 or $800,000 over and above their contract balances. So where this case will play out in that regard is if these companies are one and the same, which we believe the record clearly supports, that the funds that have been held in court in connection with the lien claim filed by Southern Steel and Concrete would be subject to attachment or subject to set off by my client Quality Iron under the subcontract. So essentially, concrete and construction should be bound under since they're the same entity, be bound under that subcontract, one of which is the Vanderbilt contract, in addition to some other contracts, Your Honor.
Which leads me to my second question, and that is this. And I don't really know because I hadn't reviewed the record yet, but for purposes of going forward, if the judgment of the trial court is affirmed, does that mean that these two companies are considered to be the alter egos for all purposes or for just this project? Or is that litigation that will need to be determined in the future? And Ms. Mathis, I'll let you have the opportunity to respond to that in your rebuttal as well.
Your Honor, I don't think you can bifurcate that fact. I think once they're an alter ego, they're an alter ego because it goes well beyond this FedEx project. As we cite exhaustively in our briefs, these companies use the same men and equipment. They had the same supervisors filling out job site reports. They had they use identical equipment, virtually 16 identical pieces of equipment. They transfer the insurance to those pieces of equipment. They utilized the same address over periods of time. So they worked for the same customers. They had 10 common customers. So you can't just parse it out saying, oh, they're just going to be alter egos for one purpose, and that's this limited time on this FedEx project. That's not what happened. And Chancellor Kyle did not limit his finding just to FedEx.
And that's my question. When I was trying to define what project was in front of the court. So the court, and your position is the court's ruling is for all purposes, these companies are alter egos, as opposed to for the purposes of the project that was before the court, they're alter egos.
And we haven't addressed the nuance of that in the brief, and I understand your Honor's question, but I think if we had a judicial determination based on a broad set of facts and multiple projects, I think we would have an order that in the event we had to apply that in a different case, such as the Vanderbilt case, that I think Mr. Rutledge and Mr. Brock would be collaterally estopped from taking a different position or would have a raised judicata effect. So on some collateral basis, I believe that finding would be applicable in the other matters.
Okay, thank you.
But just briefly back into the Dorn factors, Kyle did not misapply the law. He very much asked a lot of questions of a lot of the witnesses. The testimony of Brock and Rutledge elicited a lot of information that is clearly supported by the citations in our brief. And in fact, the parties before the start of trial filed an exhaustive stipulation of facts and of documents. And many of these Dorn factors that we're citing are supported in the stipulations at trial, in addition to the trial testimony. So Kyle not only weighed and assessed the credibility of Mr. Brock and Mr. Rutledge, as well as the Quality Iron witnesses directly, he was faced with a set of pretty exhaustive stipulations that spoke to all of these issues. And we go through all of the Dorn factors. As I stated a moment ago, there was identical management. There were a massive overlap of workers. And just because you're in a union doesn't mean you have to hire the same workers. There are many union workers that only work for one company. That was not the case here. The workers one day were working for Southern Steel and Construction, and the next day they were working for Southern Steel and Concrete. We've talked about many of the same customers were shared. They worked on 10 common projects. And, back to and I've addressed this already, Your Honors, that Tennessee law is consistent with all these factors in Dorn, and not one factor applies. It's an overall analysis based on a multitude of the factors. So there's not one key critical factor that you have to have, but it's a totality of the circumstances test, if you will. And in that regard, in the event that they are alter egos of one another, the clear language in our subcontracts, which I believe this court as a matter of law can look at, Section 2 of the subcontract, which allows set off and contribution, and Section 17 of the subcontract, which allows Quality Iron to withhold funds for liens. The court can interpret those provisions and interpret the fact that Southern Steel and Construction violated the assignment provisions in Section 11 of our subcontract, all of which are cited in our brief, that I think this court as a matter of law can state that the funds being held in court in that these entities are alter egos can be applied to Quality Iron set off, and Quality Iron should be entitled to that. So in conclusion, Your Honors, Quality respectfully requests that the court uphold Chancellor Kyle's February 19th, 2020 order, affirm that ruling that Southern Steel and Construction and Southern Steel and Concrete are alter egos of each other and one and the same and should be treated in the same manner. And that based on the legal interpretation of the clear language of our subcontract, both entities should be bound by that language and the contract balance is released to Quality Iron, or this matter be remanded for further proceedings and findings of the trial court consistent with this court's rulings. Thank you, Your Honors.
Thank you. We will hear the appellant in rebuttal.
Yes, Your Honor. Your Honor was asking about the Vanderbilt project and what's the impact of the alter ego argument. Is it just on Vanderbilt? Is it just this project, or does it include Vanderbilt, the other 8 projects that are in dispute between SS Construction and Quality? That's really an ultimate question as far as what's going to happen to these interpled funds. Are these 2 companies alter ego just for purposes of this case, or are they alter ego forever? What it comes down to is that that Quality Iron and SS Construction had previous projects with each other and fell into dispute with those projects. This one particular project that's at issue here, my client, SS Concrete, came in and basically saved the day. The project would not have been completed because SS Construction went out of business, and because SS Concrete came in and completed the project. It was done timely. It was done well. There were no complaints about it, and there were no disputes about the quality of construction or anything of that matter. And the ploy now is to use the offset clause with regard to construction previous projects with Quality Iron to prevent the people who did the work from being paid. And that's really the bottom line at this point, is that they don't want to pay. We can look at all these other machinations and whether they were alter ego or whatever, but the folks who did the work and did it correctly are not getting paid. We feel that as far as the appellee's Quality Iron's request that the contract balance be released to them, that it is not within the purview of this court because they did not appeal on that theory. The trial court awarded SS Concrete the $107,000 and conditioned the payment upon the resolution of these other issues. But the sole issue which was appealed was whether or not the companies were alter ego of each other. So we don't believe that the court should consider Quality Iron's argument regarding whether the money deposited with the trial court is due and owing to them and should be released to them. And that concludes my argument.
Thank you. Thank you. Appreciate your argument. Appreciate both of your arguments. We will take this matter under advisement and attempt to render an opinion as timely as possible. We again appreciate you participating being via Zoom. Ms. Tibner, anything we need to take up before we recess until the call of the next case?
No, Your Honor.
All right, you may recess court.
This honorable court is now in recess until 11 a.m.